Hi, everybody. Today's Facts in 5 video is all about who gets a copy of your will and when. Probate can kind of be a mystifying experience for people who haven't been through it, don't know the rules, don't know when they're entitled to get things or not. So at least the purpose of the video today is answer that big question of who's entitled to get to a copy of the will and when do they get it. So the number one misconception I hear from people when they say somebody's passed away is when is there going to be the reading of the will? And everybody knows that scene. You've seen it in movies and TV shows. All the family members are sitting around the in the lawyer's desk as the lawyer sits there and tells everybody who's entitled to what. And there's always the big dramatic scene. There was an illegitimate child who gets the bulk of the estate, or the least favorite son gets cut out. So in practice or in real life, I should say, that's not what happens. I've researched this question of where did kind of this story of the reading of the will originate. And best I can tell, it started, a couple hundred years ago, back when the bulk of the population didn't know how to read. So if somebody did have a will, they typically went to the lawyer, the attorney who prepared the will, and they would read it to them. But it was more just out of necessity, again, because the beneficiaries or the family members may not have been able to read on their own. So I think that's kind of where it started. But again, in practice, this is not something that happens anymore. So thanks, Hollywood, for continuing to perpetuate that myth. It makes for good drama, but again, it's not something that you're going to see in everyday life when somebody passes away. So who actually gets a copy? There's two groups of people that are entitled to get a copy of your will. That first group of people are going to be the beneficiaries who are actually named under the will. And the second group of people who are entitled to get a copy are the heirs at law. So the first group of people, the beneficiaries named under your will, are automatically going to get a copy when the executor or the administrator, the person who has the will, files it with the probate court. Because when they file that will with the probate court, and that's the first step in opening any probate estate, is they apply for the estate. They file an application with the probate court for the estate to be opened, and then along with that application, they provide the original will and perhaps some other documents like the death certificate and such. So when they submit that original application and will to the probate court, at the same time, the executor should be sending out copies of that will to all the beneficiaries named under the will. In addition, the executors are going to be sending copies of the will out to the heirs at law. And the heirs at law is just a term of art to describe the group of people that would have inherited from you if you had died without a will. So if you had died intestate. And the intestacy laws of Connecticut define the group of people essentially as your closest living relatives. If you're married and have kids, it's your spouse and your children. If you don't have kids, but you have grandkids, then it's the grandkids that are closest living relatives. If you don't have any descendants, then or your heirs at law, I should say, are your parents, or if your parents are deceased, it's your siblings. So again, those heirs at law are really just your closest living relatives who would have been entitled to inherit from you if you had died intestate. Important to note, however, there's also a third group of people who can get a copy of your will. They're not going to get it automatically sent to them, but they can get a copy if they're so inclined, and that is the general public. Probate court records are public record. So pretty much anybody can walk into a probate court on any given day and say, I want a copy of John Smith's will. And they may have to pay a few dollars for a copy, but they can get that document. They can get a copy of your will because it's all public record. And the whole probate process, with a few exceptions, is pretty much public record. So people can not only get a copy of your will, but they can get a copy of maybe some of the financial information that's being reported on various court forms, so people can figure out what you owned. They can figure out who's getting what. They can figure out any debts potentially that you had at the time you passed away. So it's kind of an airing of your dirty laundry, so to speak, where anybody in the general public, if they were so inclined and had a few extra dollars to pay the copy fees, can get a copy of the will and other documents associated with the probate estate. So that's kind of the short answer of who gets a copy of your will and when. For answers to any more questions about probate or estate planning in general, please feel free to check out any of our other YouTube videos that address these various types of estate planning, probate, and elder law questions. Thanks, everybody.